So the arbitration clause in the Disney wrongful death case was recently in the news. And this brought to my mind three things that you really need to look out for anytime you sign an agreement. The first one is an arbitration provision. The second one is what's called an exculpatory clause. And the third one is any kind of time limit on bringing a claim. So let's talk about each of those. An arbitration clause means that you are agreeing to arbitrate any dispute you have arising out of that agreement in your relationship with the contracting party. Now, these provisions can be incredibly broad. Things that you don't even think or contemplate could possibly be within the scope of that arbitration clause might be. And so if you sign an arbitration provision and you want to sue that other party in court, they would have the right to transfer the case to arbitration, where an arbitrator, somebody who is not elected, there's no jury, they would have the right to decide your case. And so it's very important before you give up your right to a trial by jury that you understand when you're signing an arbitration provision. Now, the second type of provision that you need to look out for is called an exculpatory clause. Exculpatory clauses are commonly known as waivers, and what they say is you are giving up your right to sue the other party for negligence. Now, in Georgia, exculpatory clauses might be enforceable. It's a very fact-specific inquiry. But even if it is enforceable, you can never give up your right to sue for what is called gross negligence. So if you sign an exculpatory clause, it doesn't mean that you're going to lose the ability to sue them for anything. It just means that your ability to hold them accountable is going to be narrowed. So you need to look out for that. The third thing you need to look out for are any time limits in the agreements. Now, sometimes a party might insert a provision in the agreement that says you only have a limited time window to bring a claim against them for something they did wrong. It might be only a year. And so if you sign this agreement and you're thinking that you have the 2-year statute of limitations to bring the claim, but it turns out you agreed you would bring any claim within 1 year, you need to be aware of that. So, in conclusion, anytime you sign an agreement, the three things you need to look out for are arbitration provisions, exculpatory clauses, and time limits.